How can employers hire workers from overseas? Are you an employer looking to hire an employee living overseas? Today's video update will help you with all the details you must know for this hiring process. Employers should be acquainted with the overseas hiring process, regardless of the grounds for hiring overseas workers. This includes ensuring they are qualified to hire from overseas and sourcing workers in accordance with overseas and Australian laws, and any industrial relations factors that could apply. In this process, the Fair Work Act plays a vital role. In certain circumstances, the Fair Work Act covers overseas workers and therefore, companies are obligated to comply with it. The Fair Work Act notes the terms and conditions for employment and the rights and obligations of employees and employers concerning that employment. So, who is covered by the Fair Work Act? Australian employers and Australian employees are covered by the Fair Work Act. The definition of an Australian employer comprises all Australian businesses, but usually excludes the public sector and local government employees. An Australian employee is an individual employed by an Australian employer, as defined earlier, or whose primary place of work is in Australia. It is to be noted that the definition of an Australian employee excludes employees who are employed outside Australia to perform duties offshore. To determine whether the FWA covers them, the following factors must be considered. Was the contract entered outside of Australia? If it was, then the employee would probably be protected by the FWA. Did the worker carry out duties from outside or inside Australia? If the employee was situated away from Australia for the duration of employment, then they are not deemed as an Australian employee. Was the worker hired to perform duties outside or inside Australia? If an employee is hired to perform duties away from Australia, they are unlikely to be considered Australian employees. Let's now find out what employers should do if the Fair Work Act covers overseas employees. If the FWA applies, employers should engage employees via an employment agreement. An employer can choose to offer them the exact employment as Australian-based employees, with a few adjustments to reflect their place of work. Employers should make sure that they are in accordance with the FWA, including the terms of any applicable modern awards. Employees are entitled to the following: leave, including annual, sick and parental leave, minimum wages, security from discrimination, security from unjust dismissal, payments for redundancy. What must employers do if the Fair Work Act does not protect overseas workers? What if the FWA does not apply? Then an overseas employee could be hired as a contractor through a contractor agreement. A contractor agreement is a commercial arrangement. An employer can choose the commercial terms of the contract without reference to the entitlement of the Fair Work Act. The benefits mentioned in employment agreements can still be offered, however, it is as the employer sees fit. An employer can also select to provide overseas workers with an employment agreement if they choose. What about the overseas industrial law? Workers may also be protected by local industrial law. An overseas worker can be protected by the Fair Work Act yet also be protected by the country's industrial laws in which they are located. On the other hand, an overseas worker may not be protected by the Fair Work Act, but they may hold entitlements through their local industrial law, for which the employer may be liable. Under these circumstances, it is suggested that employers seek legal counsel to determine what overseas industrial laws apply. When hiring overseas workers, it's paramount that employers know if the Fair Work Act is applicable to overseas workers and how those employees are engaged. Our video update for today ends here. Hit the like button and subscribe to our channel for more updates on Australian immigration. Thanks for watching.